Is your attorney working for you? Probably not. And here's three ways that the court usually uses your attorneys against you. Welcome back to Part of the People. My name is Estelle Martinez. And today we're going to be discussing attorneys. Why attorneys? Well, we spend thousands of dollars on these attorneys, tens of thousands, and in some high profile cases, we might even spend hundreds of thousands on these attorneys. Why do we do that? Well, we depend a lot on our attorneys. We depend on them because they go to law school for this. They're supposed to know more than we do. And and unfortunately sometimes we don't want to do the research ourselves, and we don't want to do the work ourselves to know exactly what our rights are. And so we depend 100% on these attorneys to defend us in court. Basically, we're putting our lives in their hands and hoping that they do the right thing. Unfortunately, I think in most cases they don't. So three ways the court uses your own attorney against you. Number one is going to be to silence you. Now, I know a lot of attorneys, if you're listening to this, attorneys, judges, and prosecutors are going to get their feathers all ruffled up right here, because they're going to say, well, most litigants don't know what they're doing, and they come in thinking that they could say and do. And they're absolutely right. In most cases, we don't know what we can and cannot do. And so, and on top of that, we allow our feelings to overtake us. And so when we walk into the courtrooms, a lot of times it ends up with us raising our voices. Um, and it could even get to yelling obscenities and causing a disruption in the court, which is absolutely not allowed in any court. Every court has its rules, and we need to be able to abide by those rules. And so we need to make sure that we do our homework to know what those rules are, and walk in there with respect. So that's number one. I get it. I understand, and I'll give you guys that much. However, it is our absolute right to be able to represent ourselves in court, and nobody can take that right away from you, not even the judge. So that is one thing that we need to be able to understand 100%. If I want to go in there and make a fool out of myself and get myself arrested, well, then that's on me. But you cannot force an attorney on me to shut me up, because that's just not legal. So while they tend to prefer you have an attorney, they cannot absolutely make you have an attorney. If you want to represent yourself, you have that absolute right. And if you want to exercise that right, you should be more than welcome to do so. Now, a lot of times it goes beyond that, and it's not just to try to keep you from making a mistake in court that could end up in jail, but sometimes it's just to silence you. They know that you're gonna oppose them, and they have other plans against you that you're not aware of, and they just don't want you to oppose them at all. And so they might assign an attorney on you, or they might even use your own attorney against you to silence you and keep you from talking in court. Now, two very different distinctions to make uh, about court is if you're one being represented versus representing yourself. When you're represented, when you go out of your way and you hire your attorney, you're making a statement to the court and saying, I'm not confident enough, or I'm not competent enough to handle my own proceedings. Don't mind my cat. uh, you're not competent or confident enough to handle your own proceedings. And so you're going out of your way and paying an attorney out of your pocket to represent you. And the court will take that as an absolute uh, way to push forward with using an attorney. They do not want you speaking out of turn, and they won't allow you to. The only time that you're going to be allowed to speak at that point is when the judge directs a question specifically to you, and you'll know that because usually they uh, talk to you by getting your name first. So, as Mr. Martinez, you know, did this happen, or can you tell us more about this, or whatever the question is, and they'll direct that question to you, And at that point, you're allowed to speak up and respond to that. Aside from that, they don't want you speaking, and they will do anything to keep you silent. So if you speak at any point, if you're hearing, um, if they direct a question to your attorney, for example, and your attorney is going to respond, and you speak up over your attorney, the judge will quickly shut you up, and they'll get to the point where if you do it enough, they'll threaten you with contempt and even jail you for it. Versus self-represented, when you're representing yourself, there is technically no one else to defend you but yourself, and so they have to allow you to speak up and defend yourself in any way possible. For example, in my own case, in the last hearing I had, we had a somewhat of a little bit of a heated discussion where I can't remember if the prosecution was involved or not, but I was speaking. The judge decided to say a few words, and then on top of that, I had a bailiff trying to tell me to shut up and be quiet, and the judge is talking silence. And I stop mid sentence and I say, I have every right to defend myself. And at that point, I hear the judge in the background say to the bailiff, uh, let him, let him. He could talk. And she had no other choice but to allow me to speak. Why? Because one, it was my turn to speak, and two, I wasn't being rude, I wasn't being disrespectful, and I wasn't being a distraction to the court. I was just simply trying to voice my points and defend myself, and I have every right to do that. And so the judge had to literally shut everybody else up and allow me to speak. Whereas in a normal proceeding with an attorney, I would have been shut up, quickly. I would have been silenced quickly. Another way they use your attorneys against you is to lead the case in a certain direction. And I'll give you an example. For my own case, I had sanctioned the DA for ex parte communication. Now, for those of you that don't understand, ex parte communication is when one of the parties, usually either the prosecution or the defense, is having meetings outside of the other party. So, for example, the prosecution is having meetings with the judge. That is 100% not allowed. They cannot have secret meetings behind your back. They could have meetings, but you as a defense has to be invited. Usually in the normal proceedings, there's attorneys involved, and so they'll invite your attorney as opposed to involving you, and your attorney will hold these meetings with the judges and the prosecution and discuss whatever they're going to discuss. But in a case where you're self-represented, you're the only defense available, and so any meetings held between the judge and the prosecution have to involve you. And when they don't, that's illegal. It's not allowed to happen. And so I motioned to sanction the DA for ex parte communication because in one of the hearings, one of the judges decides to make a statement that talks about a conversation he had with the DA, which didn't happen in open court, and therefore it's ex parte communication. All that was in plain black and white once I got the transcripts. And but point being is, once my attorney got involved into this case, the moment he got involved into this case, that was the first thing he targeted, was hitting the ex parte sanctions and moving away from it. You do not have the right to sanction the DA for ex parte. You have no evidence, blah, blah, blah. When I knew I did have evidence, and we went back and forth over this, at the end, I told him, you know what? I don't need your help with this. I know I have the evidence, and I'll take care of that myself. I'm not asking you to do anything for me. And he left it at that, because absolutely he was not gonna go against the judge. So they use these attorneys to steer the case in a certain direction. Another situation was at the end of the case. We still had a pending hearing for the sanctions, and he asks me, what do you want to do about the sanctions? Now, at that point, that was a question that caught me off guard, because in reality, I had not thought about what we were going to do, and I didn't know exactly what we could do. And so I asked him, well, you're the attorney, you tell me what can I do? He says, nothing. You can't do anything. It's already been dismissed. You can't do anything about the sanctions hearing. And so they end up closing the sanctions hearing because of that comment. Later on, I find out absolutely I could continue going forward with the sanctions hearing. And so that's something that it's still ongoing at this point. But that's just to prove and to show you that they will redirect you any chance they can. And that move was not on my favor. That was something that he was doing to favor the court, or the DA in this case. So that's point number 2. Number 3 is they'll make deals behind your back, and that's going to happen. Like I said, when, first of all, the DA will not talk to you. I have yet to hear of a case where a defendant gets to sit down with a DA, at least if they're self-represented. They will not sit down with you to discuss anything. In this particular situation, or not just in this particular situation, but in every situation, I have heard many stories about. They have to have these meetings. They will sit down. They will have meetings with your attorney and the prosecution. They have to do that in order to discuss dismissals and whatnot. A lot of times, those meetings are set with the judge. Now, your attorney can do that, but when you're self-represented, all the rules change, and all the rules change for them, not necessarily for you. The rules change for them, and they're not that difficult for them to follow. They don't want to do that. So they could still have those meetings, and probably should still have those meetings, except that they don't want to invite you, and they won't invite you. And that becomes a problem, because that becomes ex parte communication. And that's exactly what was going on in my case. And that was also proven through the transcripts of the court. So there you have it, guys. 3 ways that they use your attorneys against you. The only way to identify this is if you know, and you've done the homework, and you've done the research about what you can and cannot do in court. Otherwise, we don't know. They do it in front of us, and my case is a clear-cut evidence of that. Everything was done on the record. It's on the transcripts. In fact, you might want to go back and request transcripts for your case, because you would be surprised what you would find once you go back and reread everything that happened, everything that was said in that hearing. I hope you guys are getting something out of this. If you're an attorney, if you're a judge, if you're a prosecutor, I want to hear comments from you. I want to hear your story. I want to hear your side. Tell me, what do you think of that? I think all attorneys are against us. Prove me wrong. Prove me wrong. I want to get into this discussion with you. If you guys are just listeners and you have a story of your own, leave your story down there. I want to hear it as well. Guys, I am just starting this channel, and so forgive me. I'm not the greatest at editing and doing all that stuff, and so I'm still trying to figure out the apps for this. I'm gonna post another video, more than likely, with an actual meeting I had with my attorney, and just to kind of point out some of these things. By the way, his name's Ernie Hernandez. If you guys, and he's from Cameron County. I believe he's done some cases in Willacy as well. If you guys are familiar with this guy, I want to hear your story behind that. If you were ever appointed him, or you hired him yourself, I want to hear what what your experience was like. Tell me about it, because this guy was absolutely ridiculous. You know, in my opinion, he was ridiculous. Some of it was comical, some of it was sad, and some of it was just plain out absurd. So leave your comments. Let me hear your story. If you're an attorney, if you're a prosecutor, a judge, let's get into it. I want to discuss things with you. I want to put this out in the public, and let them decide what they think. Until next time, goodbye.